everyone. Sorry about the delay. This is Carolyn Elephant of the Law Offices of Carolyn Elephant, and welcome to what is the 12th Annual FERC Appellate Roundup. Today is December 15th, 2023, and we are going to be reviewing the FERC appeals that came up at the appellate courts for the year, as well as what I call FERC adjacent cases, which are appeals that are somewhat or somehow directly related to FERC appeals. So welcome, everybody. Feel free to post in the chat. I've got the chat box up. That's really the easiest way for me to take questions is through chat rather than through Q&A. And you can either do it throughout the presentation or at the end. So let's go ahead and get started. I'll tell you a little bit about myself. I am, I guess, what you would call a seasoned energy regulatory practitioner, though fortunately, I am practicing in a field where people enjoy it so much that they stick around for a long time. So even though I'm at the upper limits of experience here, there's still people who have got 10 or 20 years on me, which makes me feel young. So that's always a good thing. And I have been doing FERC appeals. My very first case when I started my law firm was an appeal of the DC Circuit in front of Judge Silverman. So that was a great way to launch my appellate career. And I've just been handling these cases and watching them on and off for a long time. And the opportunity to summarize the cases at the end of the year is a way that I can give back to all the colleagues who have helped me so much. And it's also a way of keeping me current on what's happening at the courts and what's happening at FERC. It is eminently more enjoyable to read an appellate case rather than a FERC 1,000-page order. Anyway, let's go ahead and get started. So we're going to cover, these are some of the topics we're going to cover. We're going to talk about statistics on FERC appeals. We'll talk about some of the, what I've referred to as FERC adjacent cases. Maybe we'll do those towards the end. We're going to talk about some standout cases and practice lessons. And then we're not going to talk so much about tech tools. I have those from my previous presentation, which I can share when I mail everything out, email everything to everyone. But we are going to talk about how AI is affecting the practice of law and some of the AI trends that we're seeing at the courts this past year. So first, the statistics on FERC appeals. So this year, there were only 21 FERC appeals as compared to 47 appeals from last year. Now, I've got to tell you that maybe I have selective memory. When I think back to reviewing the cases last year and doing the summaries, like I said, it did almost kill me, but I don't remember those summaries being as arduous as they were this year. It just felt like this year the cases were more dense and maybe longer. So even though there were 21, it felt like it was 47. So let's talk about what explains the reduction in the number of FERC appeals this year. And I had a couple of theories about that. And first of all, I think it's just the natural ebb and flow. If you look at the past appellate roundups, and when I send the summary out, when you get my newsletter, you get access to every roundup that I've done over the past 12 years. I think there was one year randomly that I skipped, but I've got summaries for all the others. So there's just a natural ebb and flow. And even like dating back to 2012 or 2013, one year there'd be like 11 cases, and then the next year there'd be 25 cases. So I think some of that is really just natural. I think we may also be seeing the effect of the Allegheny defense case subsiding. As you recall, in 2020, during the pandemic, the court issued the Allegheny versus FERC order, which effectively gutted the practice of using tolling orders. And as a result, that expedited a lot of appeals. A lot of people, knowing that Allegheny applied, went straight to the court. And that, in turn, it didn't stop FERC from issuing rehearing requests, but once FERC knew that a case was being appealed at the court, it would get its rehearing request out in that window that Allegheny allowed, that period of time before the court's exclusive jurisdiction, before the record is filed, which is before FERC's exclusive jurisdiction attaches. Like I said, last year I hypothesized that we were seeing the effect of Allegheny Unleashed, which is what prompted the 47 appeals. And I think that is subsiding. I think also now that petitioners know that FERC is inclined to act more quickly, I think they're not always as avid to get to the court. So we're still seeing people who are filing exactly 30 days after their rehearing request is denied. And we see that very commonly in gas cases, which makes sense because in gas cases, it's all about timing. If you don't challenge that project before it gets built, you're out of luck. So there's definitely for attorneys who are representing parties in cases involving construction of gas cases, you want to get into court as soon as possible. And that's still happening. But I think for some of the other types of appeals, I think petitioners are timing the appeals a little differently. So we still see people who are filing immediately 30 days after they file the request for a hearing, but we also see people waiting for FERC orders to issue before they file appeals. FERC will issue its Allegheny notice and it will say this is notice that this is final, but petitioners also have the option of waiting for FERC to act on rehearing before they go to the court to seek review. And so I think we've seen people calm down a little bit more. I think maybe there were parties who felt if we get to the court quickly, we will deprive FERC of a second bite of the apple. That wasn't happening. What's happening was when people were getting to the court with their appeal, FERC was acting on rehearing anyway, and then you would have to update your petition for review. I think in situations where getting into court and getting a resolution isn't that pressing, we're seeing it happen a little bit less and less. And so I think that also accounts for the reduction number of cases. This year, we definitely saw a reduction in the number of gas cases that had accounted for a large part of last year's docket. This year, there were only 3 cases that related to FERC approval of pipelines or LNG facilities. Okay, we have a question. Is there a requirement that a party request rehearing from FERC before filing an appeal? Yes, the requirement to file a rehearing request is in either Section 313B or 8 of Federal Power Act or 825 of the Natural Gas Act. And you've got to file the rehearing request within 30 days of the issuance of the FERC order. That's a jurisdictional requirement. Once you file that and FERC acts on the rehearing request, or says that it's going to decline to act on it and it becomes final by operation of law, then you can go to the DC Circuit. So it is an exhaustion requirement. It's a very strict one. Then the other thing I was thinking about is we've had a four commissioner commission for all of 2023. I think Chairman Glick's last day was either December 31st, or maybe he hung around until a couple of days after the new year. But the upshot is that he's been gone from the commission for this past year. So there have only been 4 commissioners. And it occurred to me that perhaps there were controversial actions where FERC was deferring action to avoid issuance of deadlock orders. Now, of course, Congress enacted Section 825G, or Section 205G of the Federal Power Act to allow for decisions in deadlock cases, at least when they involve tariffs. It allows for them to go directly into effect. And we're going to talk about what the standard of review is in those cases a little bit later when we get to the substance of the cases. I don't know if that's a possibility. My theory will probably be tested at the end of December, at the end of this year, because I think this is Commissioner Danley's, I think next week is Commissioner Danley's last day on the commission, which will leave 3 commissioners, which means that there's no possibility of a deadlock anymore, at least for the foreseeable future. And then I think if a new commissioner is appointed, I think it'll be a pairing situation where you have a Republican and a Democratic nominee. So we'll either have 3 or we'll have 5, and then we'll see if there are more cases that wind up being resolved. But those are some of the explanations, the possible explanations for why there are fewer cases. Of course, if anybody has any other theories, put them in the comments. It's the kind of stuff I love to talk about. Okay, let's go to the next side. So let's talk about a breakdown of the cases by outcome. So FERC wins 17.5 cases. I know you don't really win half a case. In this particular situation, they did. There was a Ninth Circuit appeal by the Solar Energy Industries Association, SEIA, challenging certain aspects of FERC's order 872. It was its updated rules on PURPA. And so there were 2 challenges to FERC's action. There was a challenge as to whether FERC's changes and revisions to some of the PURPA regulations was consistent with the statute. So your standard arbitrary and capricious variety of appeal. And then there was also a NEPA challenge arguing that the commission should have prepared an environmental assessment or environmental impact statement because the because the revisions to the rules had foreseeable environmental consequences. And so that's a case where the petitioners won on the NEPA issue, but lost on the challenge to the substance of the rule itself. And so that was really one where you had a win and a loss on two discrete issues. So 17.5 for FERC. FERC won. In that case, FERC won on the arbitrary and capricious on the rules revision issue, lost on the NEPA issue, and the petitioners won 3.5 cases. So that's why we have these decimal points. And if you look down the page, that's an 83% win rate for FERC, which is a pretty massive win rate. I know that if you look at the ordinary statistics for appeals, you generally see across the board for all kinds of appellate cases, you usually see an 80% or even 85% win rate. But when you're looking at the statistics across the board, that's taking into account things like prisoner appeals and pro se appeals, and so it brings the averages down. But an 83% win rate for FERC, even with the deferential standard you have for review of agency decisions, and even with the technical expertise that FERC is assumed to have, 83% rate, if you look back at my past reports, is fairly high. I don't know, there have been only maybe 1 or 2 years over the past 12 where the win rate's been that high. Last year it was 63%. It was only 55% in 2021 where there was a similar number of appeals. What are some of the reasons for that? Okay, the Allegheny effect subsiding is not, this is the wrong slide. Sorry about that. I do have theories, but these are not, oh, here it is. Okay, so what accounts for, we're going to talk about why we have that kind of outcome. So these are some of my theories on that. So first of all, the composition of the cases this year, and we'll go over a number on the substance, we'll go down over the substantive breakdown, but many of the cases this year, I think there were maybe 8 or 9 of those 21 cases, maybe 10, that's at least half. They involve sort of ISO, RTO pricing mechanisms. They get very much into the weeds. They're very technical. You can see, and I listened to a lot of the oral arguments too, and you could see in so many of these cases, the judges were really struggling to understand the case. In some of the cases, you could see that the people arguing the case were struggling to explain the cases. And so I think when you've got that level of complexity, there's just a natural inclination to defer to the agency. I think another thing that accounts for some of these wins is we're starting to see some of these environmental issues already being resolved. Now, I know that there's a whole slate of more cases that are going to raise new environmental issues. And so I'm not suggesting that if you're challenging a pipeline or bringing some other environmental challenge that you're going to be out of luck. There's a whole myriad of issues that can be raised. But in reviewing this year's cases, it also seemed that there are some issues where the DC Circuit is starting to amass enough precedent that unless you have some way of factually distinguishing your cases, you're not going to get in the door. For example, on whether FERC needs to review indirect downstream impacts of a gas project. We started off with the Sierra Club case and the Sable Trail pipeline matter, where the court said that when you knew that the gas was going directly to 2 electric plants, the downstream impacts of those emissions was foreseeable enough that it's something that FERC should have reviewed. But then we saw a whole bunch of cases where people would raise this argument and this downstream source of and there wasn't a lot of evidence on how the gas would be used, and it wasn't clear whether you actually needed to show that or not. Now it is fairly clear that you do need to be able to identify or evidence showing how the downstream gas will be used. And so if the downstream users are unknown, the court just said recently in one of the cases that was up for review this term, it said, and it was the Alaska approval of an LNG project in Alaska. And the court said that if FERC doesn't know who's going to be using this gas or how it's going to be used, the downstream impacts aren't foreseeable. So FERC is basically excused. It's off the hook from having to address that in its environmental impact review, its environmental review. And so that's a case. It wasn't clear that's how the law was going to go. But after a couple of years in litigation over time, we're starting to see what the outcome is there. And so when you have those clear parameters and you don't have the facts that are going to satisfy that test, you're going to be less likely to bring that particular case, and it's going to be easier for FERC to win on that case because it's going to draft its opinions in a way that are compliant with the guidance that the court has given. So I think that also accounts for some of FERC's wins. I think we're also seeing, and I noticed this in these decisions, this crop this year, that we're really seeing a change in the composition of the bench. And this is something that makes me a little nostalgic because I've been practicing at the DC Circuit for so long. I've argued, I'm a member of other circuits, and I've argued in other Fourth Circuit, Third Circuit, Second Circuit, Fifth Circuit, but I feel like the DC Circuit is my home. Like I said, Judge Silverman was the first judge that I ever argued before, but there's so many other great judges on the DC Circuit, Judge Rogers, Judge Tatel, Judge Sentel, who were really, they were really into these FERC cases. They really, when you heard them questioning litigants at oral argument, they really got to the core of the issues. They weren't stuck on little details. They really looked at the big picture issues. And honestly, I didn't like how Judge Rogers looked at a lot of the big picture issues, but I have to credit her for actually looking at them. I think that the newer judges on the court are not as familiar with FERC cases. I don't think they have as much of an interest for them or an interest in them as some of the other, like Sentel and Tatel and Judge Rand Williams before that had. And I think as a result, because they're not as invested, they're not necessarily probing as hard in these cases, or maybe, quite honestly, maybe they're just so frustrated at trying to understand the cases that they just don't have the energy to overturn them once they get through with the understanding. And one thing I noticed in at least 2 cases, and maybe more, there are a lot of citations to a FERC primer on energy law that I guess is up at the FERC website. I'm sure I've looked at it over the years. I'm not familiar with it. So that suggests to me when they're citing to that FERC primer that they are really trying to understand these underlying issues. And as I said, one of my practice tips is going to be that you've really got to go back to the beginning to explain these things to these newer judges and to get them invested in these cases so that you can get a good outcome for your client. So on its face, the Fifth Circuit has always been known as a forum that's receptive for appeals, but even this year it was a little bit of a disappointment. There was an appeal of a cost allocation methodology in West Connect. That was that argument. If you don't usually listen to FERC appellate arguments and you're not sure which ones to listen to, I would definitely listen to that one because Judge Jones she is really concerned about free riders, doesn't like the free rider idea at all. And her questioning was pretty, I don't want to say classic, but it's definitely something that's worth listening to. And that was one case where the petitioners did win. There was another kind of quirky case before the Fifth Circuit that came up at the beginning of the year. It was brought by the Louisiana Public Service Commission, and they were seeking mandamus or some sort of writ from the court to compel FERC to act on some of the Section 206 complaints that the commission had filed, that the Louisiana Commission had filed at FERC that were pending for, I think, 4 or 5 years. And so during the argument, the court was very sympathetic. It took umbrage at the fact that it was taking FERC so long to address these cases, that they were going on for a very long time. But ultimately, it found that it didn't have statutory authority. The act doesn't set deadlines for FERC to act on a Section 206. So the court just remanded the case initially to just directing FERC to explain why it was taking so long and what the progress of the case was. And after FERC filed its response, the Fifth Circuit denied the mandamus petition. So again, even the Fifth Circuit is not necessarily always going to be a sure bet for people who are bringing appeals. And I wasn't really certain of what else accounted for that high win rate, but these are just some of the thoughts that I had. And again, if anybody else has any thoughts, I'd be happy to hear those too. I still think these cases are winnable. And when I see a FERC win rate of 83%, it challenges me even more. It makes me want to take these appeals even more to prove that I can fight against something like that. But I don't have any other explanation. I listened to a lot of oral argument. I thought the quality of counsel arguing the case was very high. I didn't look at, I can't possibly read all the briefs, but I don't think there's been a change in sort of the composition or the qualifications of the attorneys arguing the cases. So I think it was just the kind of the convergence of these different events. And these are just based on those outcomes, just some of the recommendations that I would have for practitioners or that I will take into account myself when I am handling these cases. I think it's still really important to focus on big picture themes to frame the cases so that these judges aren't lost. Again, one of the reasons why I enjoy doing these roundups is it gives me an excuse to listen to a lot of the oral arguments. And you hear time and again these judges who are just lost or just can't figure out the case and they're in the weeds. And the attorneys are responding and giving factual answers, but they're not tying it together to the big picture issue. So when you can bring up big themes, whether it's like the free rider problems or cost causation or any of those big issues those kind of big issues that all energy practitioners can just pick out of their pocket, I think it's really going to help with the results. I think also you want to choose your battles. Don't laundry list your appeals. Don't bring these issues are so challenging. When the court has got to deal with 8 or 9 issues, you can just sense the fatigue. You can sense it just going through perfunctorily dispatching each issue in the case. You're better off with 3 or 4 strong issues or even 2 or 3 strong issues than no strong issues. And I learned that lesson. I'm going to name drop here. Many years ago, I had an appeal. It was a FERC appeal, and John Roberts was actually representing co-petitioner. So I got to work together with him, the Supreme Court Justice. He's an amazing writer, and I had a brief that was going to list like 8 issues, and he politely suggested that it might be a good idea to winnow them down, and he was right about that. We still lost the case, but it was a much better brief. And the last thing is that you want to do in FERC cases is respect the process, or FERC appeals is respect the process. And again, time and time again, I tell this to practitioners, issues like standing, responding on reply, preserving issues, you've got to take those seriously. I did hear 1 or 2 arguments where the judges were asking questions to counsel, giving them opportunities to establish standing or to show why they preserved an issue, and counsel just like jumping to different topics. And that's just stupid. You really have to address those procedural issues. And then I guess the last thing is that there have been there's one case that did resolve some of the timing issues in terms of how you count the days and when an order is considered effective, but you can avoid a lot of those issues or a lot of those concerns by just filing early and also making sure to designate all issues in your appeal. So now we're going to move into some of the substantive commentary. We're going to do a substantive rundown. So like I said, a lot of transmission issues, cost allocation of reliability upgrades, rates dominated the court's agendas. There were 2 cases involving cost allocation methodologies in SPP. I think I have got 4 PJM cases. There may have been 5. There's one, the SEAM case, which was this newfangled power pool that was supposed to be a quasi substitute for a real RTO, and we'll talk about that case is summarized because that case was remanded to FERC. And then West Connect, which is another one of these power pools, that was the subject of the free rider case that was before the 5th Circuit. There were also 2 cases that involved cost allocation for solar projects. One of the cases involved Northeast Power. The other one was the New York ISO. And in these cases, there were solar developers who sought to interconnect to either the Northeast Power, the transmission provider's grid, or to the NISO grid, and they were hit with these huge upgrade costs. In the NISO case, it's because NISO's cost allocation or cost assignment methodology for upgrades includes non-jurisdictional facilities. The solar developer argued that he didn't realize that and wasn't on notice of it, and FERC found that the tariff provided adequate notice. I think there were probably about $10 million in cost on that case. In the Northeast Power case, it involved a solar developer who I think was building 4 projects. I think the cost may have been as much as $18 million. What happened there was the developer tried to connect to distribution lines, and he was going to connect to distribution lines, but when the interconnection study was done, it was found that it would be necessary to have upgrades both to some of the distribution lines and some of the transmission lines. And as a result of a state tariff, this solar developer wound up, the transmission provider was able to directly assign all the costs to the solar developer. So it was a huge amount of costs. He tried to argue that these were state jurisdictional facilities. They were outside of the scope of FERC, and so they couldn't be considered as part of FERC's formulas or federal or the transmission provider's formula for interconnected costs. And it was also one where the developer lost. So I think that those are issues that we're going to see increasingly as we try to add more renewables to the grid. Who's going to be responsible for paying the cost of those interconnections and those upgrades? There were 3 pipeline cases this year on very different topics. There was the biodiversity case, which was a challenge to liquefied natural gas facility. It raised issues. It raised the emissions, downstream indirect emissions. It raised sort of the scope of NEPA review, and it raised a social cost of carbon issue, and the petitioner lost on all of those issues. And then Fore River and Sierra Club they were extension requests. Fore River had to do with, it was a compressor station that FERC granted an extension on construction of the facility and putting it into service, and there were new issues that arose. Anyway, the bottom line is the petitioner lost. The Sierra Club challenge that involved a Mountain Valley case. So the Mountain Valley pipeline has been stymied by all kinds of different permitting battles. It's lost a lot of cases it's lost a lot of cases. I've lost my train of thought as they lost a lot of cases. Mountain Valley had lost a lot of cases at the Fourth Circuit, and we're going to talk about what Congress did about that because the Fourth Circuit wasn't too happy about it. But one of the things that Sierra Club had argued was that Mountain Valley asked for an additional extension of time to complete construction on the project, and they argued that the company should have been required to prepare supplemental EIS. And the court actually agreed. The petitioners won on that issue. And good for them, because when these projects stretch out for a long period of time, a lot of impacts change, and also a lot of potential impacts, in this case, erosion, need for blasting and sedimentation, they become known. And they are something that should be revisited if the company is going to blow past the deadlines. Unfortunately, as well, I know I wrote this in the summary. Unfortunately, I don't know how much value that case is going to have, because now that Section 324 of the Fiscal Responsibility Act has stripped the courts of jurisdiction to review a lot of these permitting issues related to Mountain Valley and has basically ratified the issuance of the permits. I'm not really sure of the continued viability of that case, but that Sierra Club case incidentally issued like a week before Congress passed that Fiscal Responsibility Act provisions. That may have been related. Okay, I see. Okay, we've got a question here. Transmission planning and cost allocation, NOPRA. Do you think the long time before issuing a final rule in that case stems from some of the court decisions you've cited? There could be some relation. I had meant to go back and take a look at the NOPRA, because I know that there's been a big press amongst a variety of stakeholders, labor unions, environmental groups, utilities, to get that rule issued. But because so much time has passed, I haven't read the rule in a long time. And so I'm not sure like what some of the substantive topics are and whether the rule would resolve a lot of the challenges that the court heard. So that's a good question. That may be something I look at quickly before I send the summary out, because it is something I'm curious about, and I just didn't have time to follow up on it. And the Q&A is also fine to look at. So we're going to talk now about some trends and different practice lessons. And by the way, I know I'm not really citing to the cases or providing all the citations. After this webinar, you'll get the whole PDF file with the 20 different summaries. That's all ready to go. I just didn't have time to put all the citations into the presentation. This is just to be an overview that accompanies the report. So the first one that everybody is so exciting about is our Chevron watch. What's going to happen to Chevron? As you may have read in some of the trade press or the news, there's a case called Lopez Bright, which basically is going to review whether federal agencies should continue to apply. The issue is whether the court should overrule Chevron, as Chevron is the case that issued back in the 1980s, and is essentially the doctrine that we apply that's become sort of second nature in administrative appeals. The court looks to see whether the two-step process, the first step is you look to see whether the statute is ambiguous or not. If the statute is not ambiguous, then the analysis stops and you just either apply general rules of statutory interpretation or just do what the statute says. There is ambiguity, it opens the door for the agency to make an interpretation. And under Chevron, if the agency reaches that second step and interprets the ambiguity in the statute, it's entitled to deference. And that's the principle that the court will be revisiting in this Lopez Bright case. And I think there's another case. So meanwhile, there is a big Chevron dispute that arises out of an energy case. That is the SEIA versus FERC case. SEIA is named as a petitioner, even though its petition was eventually dismissed. I can't remember, I think it was for lack of standing, but there was also a group of utilities in the Edison Electric Institute that also challenged FERC's decision in Broadview. And of course, Broadview challenged the decision in Broadview. It's just not a named petitioner in this particular case, but they are the petition. We'll get to that in a second. So anyway, what happened in this case was Broadview Solar it was a project in Montana, and I think it produced, I'm trying to remember the numbers. It's in the summary, but it had an 80 megawatt. It was a combined solar and battery system, and had it could produce 80 megawatts of power and then an additional 50 megawatts, but it produced the power in direct current. And when the current was converted to alternating current, which is what you need to deliver the power to the grid, it was capped out at 80. So the facility argued that it fit within the 80 megawatt size limitations of PURPA because, as a practical matter, the most power that it could deliver to the grid at 80 times in alternating current was 80 megawatts. And so it should be considered to qualify for QF status. So initially, FERC had rejected Broadview's request to be certified as a QF. 2 years later, on rehearing, it changed its position, and it adopted the position that I just described, that because, as a practical matter, only 80 megawatts could reach the grid because of the capacity of the inverters, which converted the power from DC to AC, that it effectively was 80 megawatts and qualified for QF certification. So up at the court reviewed the FERC case. It looked at PURPA and it said, look, there's some ambiguity here. PURPA uses terms like facility, it uses terms like power production. It also has this 80 megawatt requirement, but terms like facility and what constitutes the facility and what constitutes power production are ambiguous. So we're going to interpret those terms. And we think that FERC's interpretation, or we're going to review FERC's interpretation. And so under the second step of Chevron, it deferred to FERC, and it found that FERC's interpretation of 80 megawatts being the practical capacity that could go into the grid was a reasonable interpretation. So Judge Walker went a little ballistic, started talking about Chevron maximization. He's like, hey, this statute is clear. It talks about small power production facilities. This isn't a small facility. 80 megawatts is what it says. You can't come up with these crazy interpretations to turn 130 megawatts of power into 80. 80 is 80. It's a clear-cut case. I dissent. And Edison Electric has filed for certiorari at the Supreme Court, presumably to take advantage of what's going to happen in Lopez Bright with the rulings on the future of Chevron. So it's a very interesting case. And if you look at the write-up I did, because I'm very proud of the Broadview case issued on February 14th, Valentine's Day. So it's like you've got a little lover's spat between the majority and the dissent. And you've got the majority of the court showing a little love towards FERC's interpretation. It was one of the cases where I was able to inject a little color into my summary. Anyway, what's interesting also, so there was another FERC case, as I mentioned. This is another Chevron siting. This was a SIA case challenging various revisions to Order 872. Order 872 promulgated new PURPA regulations, which had been largely unchanged since Order 69, which everybody laughs at the name of that order. The Order 69 was issued. I'm having too much fun with these appeals. I don't do this in court, trust me. It's just between friends, appellate friends. Anyways, Order 872 made some revisions to Order 69, which had been the last rule on PURPA. One of the things it did was it created a rebuttable presumption. One of the things FERC said was that originally a PURPA facility would be considered affiliated PURPA if affiliated facilities were at least a mile apart, they'd be considered separate facilities for purposes of the 80 megawatt cap. And FERC said in its rule that developers were skirting that issue and essentially aggregating facilities, like 10 facilities that were within a mile of each other, and essentially getting around that 80 megawatt cap. So it changed the 1 mile rule to 10 miles. So now if facilities are 10 miles apart from each other, then you have a rebuttable presumption that they're separate facilities. And then FERC also, I guess under the original PURPA rules, developers had the option of states had the option of setting PURPA prices either based on variable energy costs at the time that the contract was entered into, or firm energy costs set as of the cost at the time the contract was entered into, or variable costs of the power at the time of delivery. The new rule says that gives states more authority to set avoided cost pricing under PURPA, using that more variable rate at the time of delivery, and that was something that was challenged also. So the majority wound up upholding the rules, and the majority, again, in the Ninth Circuit, cited Chevron and said the PURPA doesn't give us a lot of detail about how states are to implement it, and we think FERC's interpretation is reasonable. What's very interesting is Judge Budame, I think, I'm not as familiar with the judges in the Ninth Circuit, he concurred in the decision, but specifically to say that he didn't think it was necessary to apply Chevron. He said that the rules could just be analyzed under a regular arbitrary and capricious standard, and that you didn't need to get into Chevron. So he concurred in the court's decision, but he disavowed reliance on Chevron. And I was thinking that maybe he was doing that in order to insulate the court's ruling from potential reconsideration down the line if the Supreme Court overrules Chevron. So I looked for more examples of that. I thought maybe I would see more examples of courts prophylactically or anticipatorily changing their reasoning or modifying their reasoning or giving alternative reasoning to avoid Chevron. I didn't see a lot, but then again, to be honest, I didn't see a lot of other sightings of Chevron in FERC cases. And if you follow FERC cases for a long time, Chevron does come up, but so many FERC decisions are really just administrative decisions. They're challenges to the orders, the FERC orders themselves, and they're usually resolved on APA grounds or Federal Power Act or Natural Gas Act standards of review. So substantial evidence, arbitrary and capricious. So I think the bottom line with this, the change in Chevron is for some of the bigger FERC rulemakings that we see, I think that the outcome of this case may make a difference in terms of how FERC implements policy. But I think for the garden variety FERC case, the garden variety PJM cost allocation methodology, the garden variety pipeline NEPA review, I don't really think that whether Chevron is overruled or not, I don't think it's going to make that much of a difference for the day-to-day in terms of FERC practice. You already have a highly deferential degree of review of FERC appeals under Administrative Procedure Act or under the organic statutes, Federal Power Act and Natural Gas Act. Their vibe is deferential. I don't think we're going to see that many changes. Wait, let's see. I'm sorry, I'm going backwards now. Okay, I talked about this mandamus case already. This was a petitioner who the Louisiana Public Service Commission that tried to seek mandamus relief. And the lesson here is that mandamus relief is really hard to get, even when there's been like a 4 or 6 year delay. So you may be better off trying to figure out ways to sell your case or get FERC to move it more quickly rather than going to court where you're just going to waste your time and your money. Section 324 of the Fiscal Responsibility Act, I mentioned this before. This was passed on June 3rd, 2023. And essentially, it's basically a single subject. The Fiscal Responsibility Act has a lot of provisions, but Section 324 is basically targeting the Mountain Valley Pipeline. Mountain Valley Pipeline has been, I think it was approved in like 2014. It's not even close to being built. And essentially what this statute does is it ratifies all of the federal authorizations that were issued for Mountain Valley. It vests review authority for the statute's application in the DC Circuit. Like I said, there was a case challenging a Department of Interior permit issuance in the Fourth Circuit. And the Fourth Circuit couldn't even, technically speaking, they didn't even have jurisdiction to say whether the statute applied to that particular aspect of the case. And you could tell they were fuming. They were really upset. And I guess the dissenting judge he was talking about how maybe this act even violates the separation of powers by having Congress step in to override what the agencies and the courts are doing. And that's a case that I'll be summarizing. It's an interesting issue. You just don't get to see issues like this in the wild that much. You read about them in law school, about the extent to which Congress can get involved in agency decision or court's decisions, but you don't see them in the wild that much. And like I said, it just applies to this very narrow category of cases that challenge the Mountain Valley Pipeline, but it's definitely something to follow. Let me see, I have another question here. States are looking at what happens in Chevron, and change can make a big change with state administrative law. Yeah, thanks, Cindy. That's a great point. I'm just focusing on for cases, of course, but yeah, I didn't mean to minimize the impact that overruling Chevron could have nationally for energy issues or for how we adjudicated administrative actions. That's a good point. And that if you practice law at the state level, you may want to be following that Supreme Court case anyway, because you want to see how it may impact decisions coming out of your state. So that's a great comment. Thank you. We're going to see round 2 of pipeline and LNG fights. Like I said, we're reaching a point where a lot of issues are becoming resolved, at least at the courts, some of the social cost of carbon issues, downstream emissions, but there are a lot of issues relating to mitigation and to other ways of reviewing environmental impacts of these projects that are still unresolved. There are 3 cases that are queuing up, 3 cases involving LNG challenges that are queuing up. And one of the complications or the challenges to reviewing LNG cases is that it's a very balkanized process. The Department of Energy effectively makes the determination of need because they make a decision as to whether to authorize exports from these LNG facilities. FERC has authorization over the siting, and because FERC's authorization is limited to the siting, it can't do anything about some of those impacts that relate to exports, or at least that's what the court has said. So if a petitioner wants to argue that an LNG facility is going to cause emissions and pollution and adverse environmental impacts in other countries, FERC isn't allowed, that's considered outside the scope of FERC's jurisdiction to consider as part of NEPA review, or at least that was just the holding in the Center for Biodiversity case. There maybe that's the holding I'm least familiar with, and maybe there are other circuits that are addressing that differently. But so the cases are very challenging. And then, of course, there are also jurisdictional questions as to when FERC has jurisdiction over an LNG facility and when it doesn't. And there's a whole bunch of different scenarios. If the gas from the LNG is offloaded briefly by truck, if it flows through a pipe, whether FERC is going to have jurisdiction attached. I just heard a case. There's going to be a case that gets resolved on that because I just listened to the oral argument. There's some interesting cases coming up. In one of the cases is a pipeline in New Jersey, the REAE pipeline. I'm not sure what the acronym stands for, but the opponents are challenging it because New Jersey has issued multiple filings, making findings and reports and analyses. It's Board of Public Utilities Commission did, in fact, finding that there's no need for gas in the state of New Jersey. FERC approved the pipeline and found that there was a need for gas, and the pipeline is going to cross through New Jersey. And the appeal relates to whether FERC fully considered the state climate goals when making its decision. These issues I think we're going to see increasingly frequently. Some states are really out in front in terms of electrification and reducing gas use. And it's like a slap in the face when you build a pipeline through a state that has goals of zero emissions by 2030 or 2040. So these are really interesting issues to watch. I don't like to be pessimistic and certainly would love to be proven wrong on this, but the whole reason that the Natural Gas Act was passed was to basically preempt what was viewed as state provincialism and state focus on their own state to the detriment of the nation. And I think these cases really have an uphill climb, which is unfortunate because states are really very much out in front on a lot of climate issues, and it's not fair to their residents to disregard those views. In the past, the desire when states used to block pipelines, like back in the 1930s or 1940s, it was because they wanted to promote like coal or use of some other environmentally harmful product in their borders or protect some kind of industry. But now states are really trying to advance environmental and public policy goals that are being overridden by pipelines. So it's something that's really interesting issues to look forward to. This case hasn't been set for oral argument yet, but it'll probably be decided in this crop of cases. Another interesting issue that came up, it hasn't reached the courts yet, but it relates to gas and pipeline views, is the issue of we're seeing all this renewable natural gas, artificial gas, different types of gases, and we are seeing companies that are going to FERC to either file for Section 7 certificates or, in one case, use blanket certificate authority to exercise eminent domain to build lateral pipelines that will transport synthetic or natural gas or different products like that. And actually, there's some very clear for case law. It makes very clear that natural gas, and the definition is not very artful. It's like gas that's natural and not artificial. But FERC has opined on this issue, and a lot of these types of synthetic or renewable natural gases that are being put on the market don't fall within the definition of Section 7 of the Natural Gas Act, which means that FERC wouldn't have jurisdiction to either issue certificates for these kinds of projects or for eminent domain to attach under Section 7. So this hasn't reached court case. It's not court case material yet. Maybe it will get there. We'll see. That's another issue down the pike. And then these cases solved a couple of mysteries, at least questions that I've had myself over the appellate process. So I had mentioned that back in 2018, in response to the public citizen case, the public citizen case was one where tariff or some kind of tariff was supposed to go into effect, but FERC deadlocked 2-2. It couldn't act on it. And so the tariff did not go into effect, and the petitioners tried to appeal it to the DC Circuit, which said that because there's a deadlock, there's no FERC action. So this is something that's not reviewable. So in response to that, to avoid having that non-reviewable situation come up, FERC amended the Federal Power Act to add Section 205G, which provides that in the event that the commission deadlocks or doesn't have a quorum, a tariff or another rate change or rate revision will take effect by operation of law. And that will have the effect of becoming a reviewable order. And if in the event that happens, each individual commission is directed to write a statement sort of documenting their reasons for what position they take on this issue. So in PJM's minimum offer pricing rule, which is a pricing rule that has changed many times over the years, there's like a 2016 MOPR, a 2019 MOPR, and 2021 MOPR. MOPR is basically setting the minimum prices that companies can sell power into the grid, into the PJM grid. That tariff, that MOPR went into effect through this deadlock order. And then there was also a challenge to the MOPR, whether it was arbitrary and capricious. So that went up to the Third Circuit. And people in the industry were focused on the substance of the MOPR because it has important consequences for pricing of renewables. And whether renewables that receive state subsidies can compete. I guess people have a different view of what an equal playing field is. Some people would say that the subsidies inherently mean there's no equal playing field, and others would say that if a state public policy is to give these products subsidies, then the equal playing field would allow for those subsidies to be considered when you're setting minimum offer pricing. So everybody in the industry was following this issue that came up at the Third Circuit. And the Third Circuit, meanwhile, focused its attention on what standard of review do we apply when we have a deadlocked order. And so when you look at that, so the standard of review, just to very anticlimactic, surprise, arbitrary and capricious, or substantial evidence. Like, it didn't require a 30-page order to share that detail. But so most of the Third Circuit's case in PJM, which took over a year to decide, is basically devoted to that. And then this new tariff, the changes, the MOPR changes, which made it was less likely that subsidized renewables would be penalized for selling into the grid at those subsidies, except in very much more narrow circumstances. So it's a more renewable favorable tariff. And that was affirmed, and the court basically found that FERC's development of the tariff responded to past concerns it had, and it was reasonable. Then there's also been another question. So once the Allegheny rule took effect, parties would often file a petition for review with the court before FERC had issued an order on rehearing. And so once they would file at the court, FERC again would take advantage of that 75-day window before the record is filed and before the court's exclusive jurisdiction attaches to issue a rehearing order. So the question is, let's say FERC issues a rehearing order while your petition for review is pending up at the court. You have to file a second petition for review. And a lot of petitioners were routinely doing that, which doesn't seem like a big deal. It's only a 2-page order, but it's a $600 filing fee. So that's not very cool. So anyway, in this particular case, this is the Evergy case versus FERC. The petitioner, instead of filing a new petition for review, amended their original petition for review to include the FERC order on rehearing. And the court said that was a fine way. That was an appropriate way to bring that issue before the court, as long as the rehearing request didn't significantly change or alter the underlying order, in which case you would have to file the second petition. And in most cases, FERC is really just reinforcing its reasoning on rehearing. So you're in most situations, you're just going to be able to amend your petition for review. So that was something I had always wondered about, and that issue has now been clarified. So mystery solved. And then just some other predictions, I think Tom's question, we had a question earlier about FERC's NOPRA. Maybe that will help address or refine some of the challenges, but otherwise I think we're going to consider seeing these challenges on cost allocation. There's just so much money at stake. These are appeals that they're really hard to win, but if you do win, the return is worthwhile. So I think we're going to keep seeing those kind of cases. I think we're going to continue seeing review of different transmission organization filings, the clash of gas cases with state policy, and also the demise of Chevron and what impact that's going to have on review for cases and other agency cases. And then I just wanted to briefly touch on the subject of AI and appeals and where it falls into play. I was really torn when I sat down to do my summaries this round, because I thought, am I really going to sit here? I like to consider myself very tech savvy. I'm like, am I going to really sit and summarize all these cases by hand when I can just put them into an AI summarizer? And then I tried 3 different platforms, and some of them just didn't pick up the issues. Some of them, the appeals were like as long as the summaries were as long as the case themselves. In short, and sometimes they would miss a really important issue. Like in that Mountain Valley case that I mentioned, they talked about the substance of 324, but they didn't talk about any of the separation of powers issues, which are key issues in the case. So that missed all of those. So I don't think we're at a point where you can just send all your FERC appeals or your FERC orders into the AI chopper. But that said, I think there's a couple of things that are important for practitioners to understand about AI since the launch of ChatGPT in November of 2022. One of the things we've seen several lawyers who use ChatGPT to research cases. ChatGPT, I'm sure you've seen this, many news stories on this. ChatGPT hallucinated cases, came up with fake cases. and then the lawyers were sanctioned. I think most recently, this issue has just come up in the past week in some appeal involving Trump's former counsel, Michael Cohen. I don't want to take sides on the political issues, but like on the competence issues, some of the competence of those attorneys could be challenged. So it didn't surprise me that particular appeal also involved fake cases. Obviously, if you're using AI or any kind of artificial intelligence tool to research or summarize, you just always want to read the cases. And the reason that I mention this is that it's easy to play fast and loose with when you cite to FERC orders. They're really long. You don't necessarily want to read them carefully. Or sometimes somebody might have a pleading that cites to a FERC order that you can't easily access, or it cites to a FERC pleading that was filed like in the 1970s that you can't get off the docket sheet. And there's a temptation to just cite it without reading it. And I think in the past, I'm not saying that I've ever done this. I would never, I'm very anal about that stuff. I wouldn't do something about that. But if I learned that somebody did it, I wouldn't fault them for it. And I guess the memo to practitioners is you really shouldn't do that these days. Because of ChatGPT, I think the courts are on high alert. And I think now their clerks are reading every single case and checking to see if it's a real case. So if you're ever playing a little fast and loose, and like I said, we all do it, nobody's perfect, and these cases are loathsome and boring and not always something you want to read, but be very careful to just pay more attention, because I think the courts are looking for that. Like whether you use AI or not, just make sure to use the same type of degree of diligence that you use when you cite these cases. The other thing that occurred to me, oh, and by the way, if you practice at the Fifth Circuit or you're admitted to the Fifth Circuit, they are proposing a rule that would require lawyers to disclose whether they've used AI in preparing their filings and to verify that they have read all the cases they file. So if you practice in the Fifth Circuit, you may have to do that verification anyway. The court is taking comments on those rules through January 4th. I do have mixed views on the rules, because I don't have any problem verifying that I've read every case I've cited in my brief. I'm very reluctant to disclose the types of AI or any types of practice tools or research mechanisms that I use in my practice, just because I think that there's some instances where it's really between me and my client. I consider it a privileged work product. I don't think lawyers should have to go around and show how the sausage is made in all the cases that they handle. But again, it's a basic rule. You read the cases you cite. That's not a difficult thing to agree to, but that's something, if you practice in the Fifth Circuit, you may want to keep an eye on, because other circuits may adopt a similar rule. I also wondered whether the judges are using AI in their summaries. In some of the cases, there's, especially the very long cases, there's some very nice summaries or an abstract up front. And I was thinking maybe these judges asked for a summary through ChatGPT and it came up with this synopsis. So I tried to reverse engineer it and ran some of the cases through myself, and I did not get summaries that were as elegant. So I think for now, the judges are probably not using AI even for the summaries in their cases. And if you're wondering if I used AI in my summaries, I'll be circulating them later. I think there were like, in maybe 3 of the cases that were particularly long and arduous, I did run the case through ChatGPT to get an outline of what the issues were, just so I could follow the case, because I was having trouble even following them. But I think there were 1 or 2 summaries where a portion of the issues I did summarize through AI, but otherwise it's all my original content. And when you read through it and you see all the grammatical mistakes or all the little puns, I think you will be able to guess that it's my original work for what that's worth. So anyway, that brings us to a close of the cases for the 2023 year. Sometime after this call, either late tonight or early next week, you'll get the file with all of the summaries of the cases. Does anybody have any other questions? I see a couple of other things here. Who would want to read anything written by an AI program? Yeah, no, I don't know. After reading some of the FERC cases, the summary couldn't be any worse. But no, I generally do agree with that. So yeah, so if anybody has any questions, let me know. If anybody's working on any appeals where they want to get any feedback, I'm always happy to look at what other attorneys are doing, or happy to help out with moots. When I started doing appellate work, other attorneys helped me with mock trials and with reviewing my briefs and giving me feedback. And I like to be able to give back too, and it's a good way to keep abreast of what's happening in FERC practice. So like I said, if you have any other interesting cases that you're working on or following, feel free to get in touch. And once you get the summary, if there's anything you have a question about, feel free to get in touch too. So I hope this has been a great year for everybody. Here's to 2024. Happy holidays to everybody, and hope you all get a nice break over the next couple of weeks before we start fresh in the new year. Thanks, everyone.